All rise. The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Thank you, and good afternoon, everyone, and welcome to the North Carolina Court of Appeals. We have one case on this afternoon's oral argument schedule, which is 21-656, Stockton versus Milazzo Webb Law and Milazzo. And if everybody's ready, we will be with the appellant. Oh, sorry, and to introduce the panel, I'm Judge Hunter Murphy. To my right, Judge John Airwood, and to my left, Judge Jeffrey Carpenter. Thank you.
May it please the court, Your Honor, I would reserve 5 minutes in rebuttal, if I may. A brief statement of the case. Appellant is a law firm and a principal of that law firm. Appellee is a lawyer. In 2014, in the month of September, a written agreement between appellee and appellant initiated a relationship between the two to provide legal services to the law firm. In October of 2017, a second agreement was entered into, this one verbally, called an agreement to defend. And there were time entries placed under that agreement by appellant working as an attorney up until May of 2018.
Now, you filed a counterclaim for malpractice as well, did you not?
Yes, Your Honor.
What happened to that?
Well, ultimately, there was an offer of judgment by the appellee, which I believe was accepted. I think it was for $1, but the reason why I'm reticent to respond to that is before I represented was involved in the case, but I believe that's how it was disposed of.
Well, the reason I'm asking is because it's not reflected in the record anywhere what happened to that. And so how does it show if it's a, you would think it's an interlocutory appeal if it's not reflected that that has been taken care of in any way?
I believe it was taken care of by way of the summary judgment, although the court the summary judgment order itself is very brief and does not spell out exactly what was taken up and what was dismissed. I believe it was adjudicated as a matter of the summary judgment.
Was there any motion for summary judgment on the counterclaims?
I don't know, Your Honor.
I've read the motions. I assume you have. I don't see it anywhere in them.
It did not become. It was not before the trial court, and has not been an issue between the parties, at least since the time that I began representing the appellant. The initial complaint was, or the amended complaint, was filed in May of 2019, and in the amended complaint, a breach of the Wage and Hour Act was pled, as long as breaches of contract, and there's 2 contracts that are pled in the amended complaint. First one is the employment contract that I just spoke about, and the second one is this representation contract. In the initial complaint, it had only been the Wage and Hour Act based on the employment contract that was pled, and it was added later to pursue the representation agreement as well. Summary judgment hearing took place on September 30th of 2020. The order was entered on March 3rd of 2021, and as I indicated before, the order is very brief. Indicates that an award of $20,000, $20,181 as earned wages. It has interest of $3,616 and liquidated damages of $23,797. The issue of fees under the Wage and Hour Act was left open, and it's from that order that appellant now appeals.
When did you appeal, and when was it served on your client?
Your
client's lawyer.
When was the appeal served on the client's?
When was the order, the trial court's order, served?
The summary judgment order was entered on March 5th, 2021, Your Honor, and I believe it was served about 2 weeks later, 3 weeks later, after that. The question presented from the court from the appellant's standpoint is whether or not an experienced litigator can avail himself under a remedy of the Wage and Hour Act for his work where he's expressly agreed to act as an independent contractor and has also served as an attorney.
Before we get into that, I just want to kind of follow up on your response to Judge Airwood's question. I note on page 3 of your brief, it indicates the summary judgment order is what disposed of all claims, no mention of an offer of judgment being accepted. Is it the contention that we're going to find in this record or the record supplement that offer of judgment and acceptance, and did that occur, if so, before or after the entry of the summary judgment order?
I believe it was before because I wasn't representing the appellant at that time. I do not believe it's in the record that happened. I believe it's true, and because I've been told it's true, but I don't think it's in the actual record. And again, it was not an issue that came up at the trial court during the summary judgment hearing, and it's not something that we're appealing now, either side, as far as I know. 3 prongs to the appellant's contentions. First of all, that Mr. Stockton is not an employee as defined by the Wage and Hour Act. Second, if he is an employee, there are no unpaid wages under the Act to be compensated. Third, if there are unpaid wages under the Act, that my client withheld them in good faith based on a reasonable grounds as provided by the statute. The Wage and Hour Act defines an employee as an individual employed by an employer, so it's very vague on that. It's very broad as far as unpaid wages, what those constitute. And it does say that liquidated damages shall be awarded unless the employer can demonstrate to the satisfaction of the court that their act or omission was done in good faith and based on reasonable grounds. Court has the discretion not to award liquidated damages, and that discretion will be reviewed under a competent evidence standard with respect to the facts and de novo with respect to the conclusions of law.
Looking at, just on that third point, I know you're kind of giving us an outline, but under 9525.22A1, if there's a violation, isn't it that the trial court has discretion not to award liquidated damages if it was good faith? So even if there was good faith and reasonable grounds, it's still within the trial court's discretion to award liquidated damages. Is that how I'm understanding the statute correctly?
That's accurate, and that's what the case law bears out, that the trial court has the ability to do that. Now, trial court is also obligated to make sufficient findings of fact and makes a conclusion of law that's reasonably based on that. And here in this order, there are no findings of fact. It's very brief. There's nothing to set out why the court determined that there was no reasonable basis. So there's nothing really for the court to look at least with respect to the order. But you're right.
So would our result, if we agree that there was something to show good faith, would our result be just to remand that as opposed to reversing? Because that's not something we would have independent discretion to exercise, right?
It's the trial court's discretion. The trial court exercised that discretion, but there's nothing for the appellate court to review to determine what that discretion was based upon. So I think the court is right. You would have to remand that because there's really nothing for you to go on in the record. With respect to the first prong of the argument,
I want to go back to this, to when this order was entered and when you were served, because this says that the order was filed on 5 March. There is nothing that I can find in this record that shows when this order was served, but your notice of appeal was the 23rd of April, which is clearly much more than 30 days past 5 March. So how is your notice of appeal timely based upon what's in this record before us?
Your Honor, I'm just not ready. I'm not prepared to answer that question because it's not an issue that's been raised. I believe there was a time gap, if I recall, in between the entry of the order and the time it was served.
But you're the appellant, correct?
Correct, Your Honor.
And you have an obligation to prepare a record that shows jurisdiction, do you not?
Yes, Your Honor.
Then why are you not prepared to answer that question for me? Because that's a part of jurisdiction if it was timely filed.
I agree, Your Honor, and I'm going to answer the question. I don't have it in front of me. That was not an issue that I'm prepared to address. I believe it was timely filed, and I don't believe that appellee has ever taken a position that it wasn't. If it wasn't timely filed, there's a remedy for the appellee, and that is at the trial court level to make a motion that
Well, but you've got to show jurisdiction here for us to be able to consider it. and whether or not you timely filed a notice of appeal is a jurisdictional issue, as this court has held on many occasions. That's why I'm asking you these questions.
Yeah, I agree, Your Honor, and I'm going to answer that question. I don't have it in front of me right now.
Continue.
Thank you, Your Honor. As to the first prong of the argument, whether or not Mr. Stockton was an independent contractor, as I said, the Wage and Hour Act is vague and circular as to what constitutes an employee. An independent contractor is not an employee, but the statute itself is not helpful, and neither is the Fair Labor Standards Act, which is they're based together and have the same law. So we have to look at the law that has arisen surrounding it, and as a rough consensus of what that law says is that the labels don't really matter. What you're called, or what someone calls you, whether you're a partner or not, that's not really probative. What is probative is the actual circumstances of the worker's relationship, and whether or not a determination could be made as to whether or not he's economically dependent on the business or he's in business for himself. That's really the heart of what most of these cases say, and most of them say that that has to be done on a totality of the circumstances and on a case-by-case basis to make that determination. The two probative factors that are in most of the cases are the degree of the employer's control over the employee's work and whether or not the employee had an opportunity to profit from his work, so control and profit.
How did your client hold the plaintiff out to its clients?
Well, there was a period of time where he was working as what was set out as an independent contractor in the...
How did they hold him out to the client? Not what does the agreement that you're talking, not what does that letter say. How were they holding it out to the client?
I believe, Your Honor, as a partner starting in 2016 and onward, I believe. And the reason why I believe that is in 2016 he began receiving a K-1 rather than a 1099. And I believe within the firm he was categorized as an income partner at that point rather than an equity partner. Although, again, under the cases, that's not determinative of whether or not he's an employee or an independent contractor.
How is he incorporated, if at all, under the malpractice policy that the firm
The firm paid his malpractice. However, under the independent contractor agreement, that was about the only thing the firm paid.
Did the firm have, let me follow up on Judge Murphy's question. Did the firm have a single malpractice policy that covered all the folks who were working there, who put this law firm's name on the things that they sent out?
So what the independent contractor agreement says is that he will be covered by their malpractice coverage. Whether that applied to everyone who was working there, I don't know.
So they had a malpractice policy, and the plaintiff was listed under the firm's malpractice policy.
That's right. That's right. As to other aspects of being working for a firm, for instance, how you received your tax treatment. He was 1099 for 2 years and then a K-1 thereafter. He had to pay his own Social Security taxes, his own unemployment taxes, and any self-employment or other business taxes. He had to pay his licensing fees, his business practice fees for his practice license, and his CLE fees. So it's really the malpractice coverage, I think, is the sole coverage that was provided him by the firm. He also was not paid a salary under his employment agreement. He was to receive a portion of the fees that were collected by the work that he did.
Well, fees that are collected that if you're entitled to, aren't those wages under the North Carolina Wage and Hour Act?
It depends on whether or not you are a independent contractor or an employee. Here is an independent contractor, so no. Wages are defined very broadly.
If we disagree with you that he's an independent contractor,
I'm sorry, Your Honor?
if we disagree with your position
Right.
that he's an independent contractor, are the payments that he received for the work that he did that your client received back from the firm, are those wages under the Wage and Hour Act?
For the period of time that he was working there until termination, yes. If you find that he was an employee rather than an independent contractor up until the date of termination, they would have to be considered wages. But because the agreement itself said explicitly, in order to receive payment, you must still be working at the firm. Fees collected after termination remain with the firm, and that's explicit in the contract. Because it says
Well,
that.
can an agreement override the Wage and Hour Act?
If the question is whether or not someone can waive their status as an employee, I'm going to say no. So if he actually was an employee, the fact that he says he's an independent contractor, no, that would not trump it. However, it is still material that he agreed that he was an independent contractor in agreement 3 times under this particular set of facts because of who he was. And again, the cases that all define this don't have one set of rules that applies to everybody. They can't. It's a case-by-case totality test. This particular attorney was an experienced employment attorney. So for him, after 15 years of practice, to sign an agreement like this is different than someone who's brand new to the practice. It's different from them signing it. The case cited by
So it's
Appellants for
your
this, the
so
Steelman case.
Let me understand. It's your position that that someone's experience determines whether or not the Wage and Hour Act applies? That if this was someone right out of law school, then the Wage and Hour Act might apply, but since he's been out for 15 years, the Wage and Hour Act wouldn't apply?
Yeah, it's exactly what I'm saying, Your Honor. And a pretty good example is my associate here, Mr. McLeod, who's with me today. He's in a far different situation than Mr. Stockton, even if we had the same written agreement. He's paid a fixed salary. It's paid on a biweekly basis. I pay his taxes. I pay his employment taxes. He receives a W-2, not a 1099. He can't make any more money other than what I pay him. He doesn't have any profit upside. He's paid what he's paid. I have a certain number of hours that he has to work a month to be in good stead as an employee. But most importantly is I closely supervise him because I've been practicing law for 25 years, and he's in his 3rd year of practice. He's far different situated, and if I was arguing to the court right now that he should be considered an employee, I think I'd be wrong. Or not employee, I think I'd be wrong. He clearly must be because he's in the mode of an apprentice. It's far different for a seasoned attorney who already has his own business to take that business and arrange it with an existing law firm in a way that best suits him. I mean, lawyers have done this for a long time. Contract attorneys are nothing new in the state of North Carolina, and there's a lot of attorneys who do not wish to work full-time, who are fully experienced and don't need to be supervised. And this particular agreement that he executed was perfect for that kind of practice because he was to get 75% of whatever was collected that he worked on, 25% went to the firm. He didn't have to work any set number of hours. If he didn't work any hours at all and he didn't occupy an office, he'd owe the firm $700 a month. If he did occupy an office, that's $1,700 a month. That's just a chair fee. In this way, not supervised by a transactional attorney because he couldn't be, he's really no different than, say, a hairdresser renting a chair as part of a boutique or a taxi cab driver who's working for a taxi cab company who's not under any direct supervision.
I want to go back just and look at some of the novelty of Judge Airwood's question a little bit more. And why would it, under the statutory language that the General Assembly has put in place, what says that we should take into account the level of experience of a person in whether they're an employee or not? And, you know, the General Assembly can pass whatever policy they want when it comes to this. So what in the statutory language would point us to that there is this additional consideration to be given based on amount of experience or practice area or things like that?
Statutory language, nothing.
Yeah.
It's the cases that say it. So there's very few cases in North Carolina that address it directly. One of them would be the Horak case. And the Horak case was very similar in the sense that there was a tail commission involved for a real estate broker. And he said that he was entitled to it. The employer said that he wasn't. And the Horek court applied a test that's slightly different than the federal courts generally do, because the first prong was control, that's the same. Second one was permanency of relationship, was slightly different. But again, got to the same point, which is you have to look at the totality of the circumstances, peer beneath the label, and see what it is that is actually happening. What's the economic reality of this relationship? And the economic reality of every employment relationship is different. And I would contend to the court that the economic reality of relationships between lawyers and law firms is unique amongst any employment field, because we have twin duties, one to the people for whom we work, and the other to our clients. And those client duties are governed by ethical standards. So it's far different to say that a lawyer who's experienced should be considered as an employee and a lawyer is inexperienced. It's just two different kettles of fish, and the law allows for it. That's why the law continually, that's why in the cases they continually conduct this kind of analysis and say what's actually happened here. And in all the cases cited by the appellees, there's this consistent parsing out of what was really happening, how was this person actually situated. And if you apply that general idea, and again, it doesn't reduce itself to a test or even a set of prongs that are consistently used. You have to look at the situations why we contend it needs to go to a jury, is determine whether in this case, based on his level of experience and the agreement that he signed and agreed to live by.
Well, but isn't whether or not someone is an employee, isn't that a question of law, sir?
I do not believe it is, Your Honor. I mean, it consistently goes to a jury to make that determination. Many of these cases are jury cases.
Are most of these factors objective and not subjective?
Most of them are subjective. However, it is an objective factor for the liquidated damages. That's an objective test. So for the liquidated damages, that doesn't go to the jury. That is a question for the court to determine whether or not there's a reasonable basis, whether or not there's good faith and a reasonable basis. And the court is supposed to make that determination objectively. So in this case, what the trial court should have done is determine whether or not a reasonable employer, like Ms. Milazzo, a transactional attorney, whether it would have been reasonable for her to believe that Mr. Stockton was an independent contractor. Well, he signed an agreement 3 times that said he did, or an agreement that says it 3 times.
Mr. Rhodes, why would it end, well, let me rephrase that. You referenced an income partner. You also referenced that the plaintiff in this case received K-1s in 2016, 2017, 2018. Equity partners or ownership interests receive K-1s. Why would Mr. Stockton receive a K-1?
He was...
if he's not an equity partner.
Well, that's a pretty good tax question. I believe if you are a member of an LLC,
Right.
then you receive a K-1.
Mr. Stockton was not a member of the LLC, if
I agree with
understand
that.
your argument correctly.
That's right. I agree with that. Which is more reason why there's no one single thing you can look at and say, well, because he received this or he received that, this is what he actually is. He could have been of counsel. He could have been called anything. None of those things really matter. Several of the cases that are cited by Appellants say that the labels don't matter. Really, it doesn't really matter what form he received at the end of the year.
Well, the tax treatment is informative as to what role he actually played. If he's a 1099, he's more likely than not an independent contractor. He's W-2. He's an employee. If he's a K-1, he's an equity owner.
Respectfully, I disagree that the cases say that, Your Honor. I think the cases say that that's not determinative. So two pretty important things. Number one is an individual worker cannot wave away, simply say, I am an independent contractor, and thus I can't then be considered to be an employee under the Act, if in fact he should be. Nor can a worker, just by virtue of receiving a particular tax document at the end of the year, lose his right to avail himself of remedies under the Wage and Hour Act.
Well, but doesn't that argue against the position you're taking in this case?
It does not at all, Your Honor, because we are not contending that that's determinative. We're not saying it is. But I'm answering the question as to what it actually means under the law.
Well, you talked a lot about this contract and saying he was an independent contractor 3 times. It seems to me that that's one of the things you're arguing pretty strongly.
With respect to him. So in a general sense, in responding to Justice Carpenter's question, in a general sense, it doesn't matter what document you receive. So, if someone who is fairly unsophisticated receives a K-1 or a 1099, doesn't know what to do with it, that's not indicative of anything. If they sign a document that says they're an independent contractor, as the Steelman case sets out, that someone who has unequal bargaining power may well sign a document that puts them in a bad position because they don't have any choice. That's not the case here. That's why it has to be case to case. If you take a seasoned employment lawyer who looks at a document that says, I'm an independent contractor, says I'm signing that, has been a lawyer for 15 years, knows how to negotiate, we can assume, and sees that I'm going to be paid by 1099 rather than W-2, that means something much different for this particular case than it would be in another case. So in a general sense, it's not determinative. In this specific case, it's material because it means something with respect to him, how he can be seen by the court. And because he is who he is, we contend he should be seen as an independent contractor.
Well, if that's the case, you're telling us a little bit in your intro that, and we're coming right up on your 5-minute rebuttal, but that he only gets paid the percentage of what gets collected. This situation, there's nothing to be collected. So how could that, even if there was some independent contractor aspect of his employment, I'd like to hear when you come back up how that can even come into play about the monies owed here, because this would have been completely outside of that independent contractor situation that you described to us earlier.
So I'm going to take 30 more seconds of my rebuttal to answer it now. The first part is because the monies that were contended to be owed, the $8,000 under the employment agreement, because those were tail fees and he agreed that he wasn't entitled to them, then he's not owed because he agreed to that, even if he was an employee. As to his legal fees, they can never be subject to the Wage and Hour Act because it's a completely different relationship. Mr. Stockton's unique here. He wore two hats. One as a worker, we say independent contractor, they say employee, and the second as an attorney, just like I am now, not subject to the control of his client, and the more he works, the more he gets paid. So those two different hats are critical in this particular inquiry. So I'm going to, if I can, I'm going to reserve that last 3 minutes and 48 seconds and try to answer your question on rebuttal, about service of the judge.
May it please the court, my name is Jared Gardner. I represent the appellee, Colin Stockton. I'll begin with, I know the answer to a couple questions, answers to the couple questions that Mr. Redding did not, and Mr. Redding also misstated a couple things that since you asked about, I think they might be important. Mr. Stockton did not have his own unemployment insurance. Milazzo Webb supplied everything. I think Judge Arrowwood, that you also asked whether there was a single policy for malpractice for all of the attorneys. Yes, there was. There was a single policy that covered everybody. And I'll add to that
Is that in the record anywhere?
Yes, sir, it is.
Okay.
And I'll add to that, and this is also in the record, that the application for those policies, Milazzo Webb identified all of its attorneys of every characterization, of every type, as their employees when they were applying for that and got that insurance. Milazzo Webb as I said, paid the unemployment taxes. They paid workers' compensation. They had a 401k plan. They had a health care plan that was employee coverage for all of these attorneys regardless of characterization.
And is that in your documentary exhibits that are supplemental to this, or is that?
Yes, Judge, it is in the record. They're in the Rule 11C supplement, which you may recall is rather large. It's all in there. And in our brief, we have been very careful to cite to every single page of that supplement or of the record of where it is. It's all there. Try to figure out the order in which to do this. It covered it quite a lot. I'll start here, that we have a very odd situation here. I find it to be very odd, where you've got a putative employer that is trying to look behind its own label to find something different than what it labeled its worker. So you have Colin, everybody agrees he is a partner, a K1, they call him a partner. He's called a K1 member. Okay? And as a matter of fact, I mentioned this in our papers, I mean, that was the basis for their own motion for summary judgment. They write, it is undisputed that Colin Stockton was a K1 member of the firm. But by the time you got to the hearing, and I think this is after they got our papers, quite frankly, realized they had a problem, they dropped that. And then they kind of squirreled around and they said, and this is in our papers too and in the transcript, they said he's an independent contractor-ish person working at the firm. I don't know what that means, but that's not a legal status for anything. Now we're before this court and they're arguing he's an independent contractor, not a partner, an independent contractor. And I would say to the court, first off, I just don't think the court ought to entertain that. And the reason is that the difference between a partner and an independent contractor, it's not subtle. They're diametrically opposed. They can't exist together. When you are a partner at an enterprise, when you are a part of an enterprise, you are part of that enterprise. You are yourself the employer. I'm a partner at my law firm. I'm the employer. I am not an employee. I'm part of that enterprise. When you're an independent contractor, you are wholly separate from the enterprise and in business for yourself. That's the very definition of an independent contractor. So it seems incredible to me that you ought to be able to say, give us summary judgment because he's a partner, and then say, okay, no, wait a minute, reverse summary judgment because now we say he's an independent contractor. There are two tests that apply or that can apply depending on the circumstances. And we've got these, we've cited these for you in the case. It starts with Wheeler back in 1987, I think it was. They're all circuit court cases. And what those cases look at is they have a situation where they have a partner, someone who is part of an enterprise, and the courts are trying to decide, well, I guess one party is arguing here, use this test over here for independent contractor. And what the courts say is, no, we can't use the test for independent contractor because this person is part of the same enterprise. It makes no sense. So what the real test is then is this putative employee a bona fide partner? Is he a real partner? He's got the name, Colin's got the name, but is he a bona fide partner? And if he is a bona fide partner, well then he's the employer, and he's not the employee under the FLSA or the wage, or in this case the North Carolina Wage and Hour Act. But if he's not a bona fide partner, well then he's an employee. That, your honors, is the test that applies in this case, and not just because they called him a partner, but because that was the reality on the ground. That is what the evidence shows. They called him a partner. His letterhead was Milazzo Webb. His email identified him as a partner of Milazzo Webb. He's under their insurance. He's got an office in their building. He's got 401k through Milazzo Webb and health insurance and everything else. He is connected with Milazzo Webb. He is in no conceivable way separate, and that's true with respect to all of the work that he did for Milazzo Webb. So that's the test. And then here it even gets easier because the test is, are there trappings of actual partnership? And what these cases will do, Wheeler, and I would submit to you, your honors, this is the easiest part of your job. Because in these cases, there was a question about it. Well, he had this kind of, maybe a little bit of voting right over here, and maybe this kind of right over here as a partner, or a little tickle here, or something, little bit, things to weigh to decide whether or not this person is a bona fide partner. This case, there's nothing to weigh, nothing. Colin has absolutely zero trappings of a bona fide partner. He has no ownership. He has no sharing in profit or loss. He has no liability for any firm debt. He has no vote whatsoever. He has no ability to affect management at all. There's nothing there. And that is all in the record, and there is not one iota of evidence from the other side to try to rebut any of that. So I would suggest to this court, that's the end of the inquiry. He is an employee under the North Carolina Wage and Hour Act. But why stop there? We can go to independent contractor. And attached to our brief, Your Honors, is a appendix. And the appendix is what we initially gave to the trial court, and it sets out in detail just everything, all of the evidence. And I want to emphasize, too, this evidence all comes from Milazzo Webb or Milazzo Webb's attorneys or Milazzo Webb's officers. All of it. Nothing from Colin. This is all of their admissions, all of their documents, all of their testimony. And Mr. Redding talked about control. That's their whole main focus here. Look, Colin Stockton is an experienced attorney, so we don't have to control the way that he does his work. I have to make a super quick aside here, because if I don't, I'm afraid that I'll forget it. There is no Colin Stockton exception to the rule that you cannot contract your way out of the North Carolina Wage and Hour Act. There's no exception for Colin Stockton. There's no exception for any attorney. There's no exception for the most brilliant person in the world, the most educated person in the world. There's no exception. It just doesn't exist, and it shouldn't exist, because how in the world would you ever make those determinations? Well, you had this much education and you had this much experience, but it just doesn't exist in the law, so that it doesn't even need to be addressed. Now, if I can get myself back on track on independent contractor, this is the evidence that was before the trial court and is now before.
Before we go into that, 'cause
Yes, sir.
I want to give you more time in that, but with the partnership relationship, potential partnership, your client was an experienced employment attorney receiving a K-1, and he knew what that meant. Did he have access to the books to see what percentage of the annual profit he was actually receiving, or did he just accept a K-1 without any care in the world as to did this accurately reflect his ownership interest, and then submit that to the IRS?
Yes, sir, you ask a fabulous question. His K-1 did not reflect any profit or loss of Milazzo Webb. It didn't. He didn't have any right to any profit or loss to Milazzo Webb. They didn't treat him that way. They called him a partner. They gave him a K-1. They avoided paying their portion of employment tax, but everything else was strictly as an employee. He got paid what
They
he
could have made that
earned.
same avoidance as a 1099, but the K-1 should have also disclosed what his ownership interest is, and if it's zero, probably shouldn't have been receiving a K-1.
Perhaps not. Now, I'm not a tax lawyer, so perhaps not, but I would suggest to you, Your Honor, that the issue before us is he an employee?
Well, I guess part of the issue I have is the elephant in the room here is, did your client come to court with clean hands or unclean hands based on his receiving a K-1 and apparently filing that with the IRS? And if not, does it actually matter, given that this is a statutory action, and do unclean hands factor into it at all?
Well, I would start by saying that unclean hands do not factor into it at all. This is a pure statutory issue. To answer unclean hands about accepting a K-1 and being, I don't know that was his responsibility. I don't think any of that is in the record about, whether he should or shouldn't have done that. There's a second part to your question that was more important. Maybe you remember it better than I did.
About what he was, and it may or may not be in the record from my recollection, of what he was representing to the IRS as to his partnership status. And if he's representing himself as a partner to the IRS, then why shouldn't he be held to that by filing a K-1 showing he had a membership interest?
This is not a new, this is what happens in every, This issue of misclassification and issuing 1099s and K1s, I mean, it's a problem throughout the country. But what the case law says, it doesn't matter. It doesn't matter what you agree to. It doesn't matter whether you receive a 1099. It doesn't matter whether you receive a K1. If you are an employee, you are going to be held to, or the employer is going to be held to the strictures of the Wage and Hour Act. You are an employee that is protected by those protections. And I think, Your Honor, it just, as a practical matter, and just, I mean, it just has to be that way. You can't, there are a multitude of circumstances where people are saying, okay, I'm going to hire you as a 1099 employee. That's what, that came up in this case. I love that term, 1099 employee. There's no such thing. But we're going to issue a 1099. And there's an issue of bargaining power. And so this would take me back to saying there is no Collins-Stockton exception.
Well, I agree with that part of the principle in terms of what somebody receives not mattering. But then what he represents to the state government and the federal government, to me, seems different than just what somebody receives that they don't have control over. It's, you know, it's not necessarily a judicial admission, but it's an admission to a government entity that I have this status. And have any of our past cases focused on the acts of the employee or independent contractor and what they're representing to those entities? From what I've gathered, most of the case law just has been focused thus far, and maybe that's all that was there and in that record, and it didn't matter, on what the employee was receiving or the independent contract, however you characterize what they were receiving, doesn't matter. But to me, there should be some purpose, and it should matter what Mr. Stockton is saying to the world about his partnership status.
Yes, sir. Judge, and I understand your question. And I think if I could restate your question like this. If a person gets a tax form, and it's a 1099 or it's a K1, and they submit it to the IRS, is that I'm not sure what to call it either, whether you'd call it an admission or call it, oh, now you're stuck with that. And the answer to your question is a flat, absolutely no.
Because the statute is how it is and makes no equitable determinations in terms of that aspect of the relationship.
I would say that that's one reason, but I would also say that there's just absolutely no law to support it. And if there were a law to support it, I mean, respectfully, I think that the chaos that would ensue would be amazing. All you need to do is issue a 1099 to somebody, they do their taxes, you know, and all of a sudden, boom, you're not an employee anymore, you're not entitled to the protections of the FLSA and the NCWHA. It couldn't work that way, and there's just no law to support it.
But has any of the cases mentioned factored that in at all, one way or the other, or dismissed it as a factor?
I have never seen it even so much as a footnote. I've never seen it, Your Honor.
Thank you.
Okay. Go back to the independent contractor, although Judge Arrowood, you look like you might have a question.
I do, but it's not on this. It's about, let's say he's an employee, then how are the fees that he's billing to the firm, how are those wages under the Wage and Hour Act?
I love that question too. I love it because I've thought through this. An employer can change the promised wages at any time. That does not change the employer-employer relationship. And I'll just give you an example off the top of my head. Suppose you've got a salesman at a car dealership who is just working on pure commission. He's a great salesman. He makes tons of money making commissions, but he also works on engines pretty well. And so the employer goes over and says, hey, I'd like you to work on these engines over here. I realize you make commissions here, so I'm going to pay you X dollars an hour to do this. Okay, that's his promised wages. Now, that doesn't change the relationship at all from employer to employee. In this case, that is precisely what happened. We've got Colin Stockton who is a Milazzo Webb attorney. He works on the split of collection model. Brandy Milazzo, the partners come to him and they say, we would like you to handle this case against these 5 other Milazzo Webb attorneys who are bringing wage claims. And she says, and we'll pay you. Keep your time. Okay. He does it. Now, that doesn't change the employer-employer relationship. That's just a different promised wage. And I would point out at this point, and I said it in the brief, but I'll mention it again, in Brandy Milazzo's affidavit, she talks about how she testifies that Colin was going to issue an invoice, and that he didn't issue an invoice. And so what do you think of when you think of that? You think, okay, well, Colin Stockton, PLLC, is now taking this over, or Colin Stockton, the human being, is now taking this over, and he's going to issue us an invoice at the end of it. But in the very same affidavit, she attaches the invoice. And the invoice is from Milazzo Webb. They generated the invoice payable to Milazzo Webb. It's got nothing in the world to do with Colin Stockton, and no one would ever expect it to. This was all internal at Milazzo Webb. It's their invoice commanding themselves to pay themselves. I will say this too, and I was going to get into, I may not get there, but I was going to get into the independent contractor pieces of this, is that Milazzo Webb had mandated in writing to be complied with by everybody that no Milazzo Webb attorney shall serve any client except through Milazzo Webb, not even personally. That's written down. It's testimony from Ms. Milazzo saying, yes, that was the mandate. And believe me, that is one of many, many, many mandates that if I get a chance, I'll read something to you unless you tell me you're just not interested.
Speaking, I want to go back to the invoice situation real quick and just ask this question. Did he use the firm's internal timekeeping, record-keeping software, whatever mechanism,
He
just
did.
like he would with anything else going on?
He did, Your Honor. They have Clio. He's got cases. He enters his time into Clio. They called this the...
So if he was working on the Smith case from 10 to 12, and then he's turned into this from 1 to 3, it's all in that same timekeeping system.
Yes, sir, it is. They gave it a name. They called it the conservancy matter. I don't know why they gave it that name, but they gave it the conservancy matter, and that's where he enters his time into their Clio system that generated the invoice you're talking about.
Thank you.
We talked about the bona fide partner test. I think that applies. I wanted to emphasize that even if the independent contractor test applies, the evidence that you've got, that the trial court had before you and that you have in the record is just overwhelming. And there's not one iota, and I'm not, there's no exaggeration here. There's no evidence going the other way. And I wanted to just, if I may, read some of this to you. This is the chief operating officer testifying. Independent contractors were under the sole direction and control of Milazzo Webb. She testified to that. A former partner there, Suzanne Schaefer, testifies, Milazzo was the boss, quote unquote, of all MW attorneys, regardless of their status of W-2, K-1, or 1099, instructing them on what to do and how they should do it. All attorneys, regardless of classification, comply with all firm policies which are subject to amendment by the owners whenever they like. I think I mentioned this, servicing clients as a lawyer only through Milazzo Webb and through no other persons, including personally. Keeping and maintaining records. And this goes on and on about professional services rendered, preparing and attending to, connection with such services, billings, reports, claims, correspondence necessary or appropriate in the circumstances, all of which billings, records, and this is what I think is the most important part of this one, all of which billings, records, reports, claims, and correspondence will belong to MW, belong to Milazzo Webb. required to attend professional conventions, organizations, contribute to articles, all for the benefit of Milazzo Webb and its clients. I'm trying to paraphrase this because I used up all my time reading every bit of it. I guess I could probably stop here. I mean, there are pages and
If there
pages
are
of
certain
mandates.
record pages or record supplement pages you want to make sure, give our attention to without having to read from them, feel free to do that, and we can go back and look at this video too, if you want to just give us a quick rundown.
Your Honor, it is, the appendix to the brief, it's pages 26 to 39. Unfortunately, when we did the appendix, we didn't also have the record pages and the record supplement pages. Those are all set out in our brief, but more as string sites, so you're not going to know to go here for here for here. I actually do have them written here, but if I read them all out to you, I think I'd run out of time.
That's all right. Thank you, sir.
Liquidated damages. This is so, well, anyway, it's
Why did Judge Bell not have to make findings with respect to liquidated damages?
because this was a summary judgment motion, she didn't need to make any findings, and she didn't exercise her discretion. And the reason she didn't need to make findings, Judge Arrowwood, is because when the appellees failed to meet their burden to show that they had a good faith, reasonable basis for not paying Colin, then liquidated damages are mandatory. No discretion, just mandatory.
And so it's your position that once she ruled against them on summary judgment on that liquidated damages become mandatory and she doesn't have to deal with the good faith exception?
Yes, sir, and she awarded them. The reason I hesitated a little bit before getting into liquidated damages is because the appellees have made various arguments. Their arguments change. Sorry, sir.
No, go ahead.
At the trial court, they first said that it was good faith not to pay Colin because they had a good faith belief that he was a partner. Now, they've abandoned that altogether, and they say he's not a partner, he's an independent contractor, so that's just gone. But I'll make a point here, is that whether or not they believed that he was an independent contractor or a partner, and therefore, I suppose, wouldn't violate the Wage and Hour Act because they could just not pay him and not violate the act, that's not the issue. The statute says that if the employer shows to the satisfaction of the court that the act or omission constituting the violation was in good faith and reasonable, the act or omission in this case is not paying. They didn't pay. That's the act or omission that got them into this trouble. So they need to show that they had a good faith and reasonable basis not to pay him. It doesn't matter whether they thought he was a partner so that they could get away with not paying him and not get in trouble under the act. What matters is, did they have a good faith and reasonable basis for not paying him? And they just plain don't. Perhaps what makes this the most clear, when he's doing this work for them, trying to settle these cases with these other former Milazzo Webb attorneys who who had wage claims, they told him, keep your time, we're going to pay you. Then Ms. Milazzo said, we'd like to settle with you up at the end. When you get to the end of the settlements, then we'll pay you. So we get to the end of the settlements, and this is May of 2018. We're at the end. So Colin says, hey, I'd like to get paid. And they didn't pay him. And the only reason, Your Honors, they did not pay him was because of cash flow and prioritizing other financial obligations over paying Colin. A partner at Milazzo Webb testified to that. That is the only reason they didn't pay. So that violation under the Wage and Hour Act occurred at that moment. And there was positively no good faith, reasonable basis for not paying him. Not having money and prioritizing other obligations is not a good faith or reasonable basis not to pay wages.
You say it's a partner. Is this the partner who left, who testified to this, or is this the partner who's
This
still
is the
there?
partner, Danielle Webb, who was there and a partner at the time she testified, I believe. She testified twice, so I'd have to confirm that, but I believe that's true. Then months roll by, he's not getting paid. Let's see, in September, they paid him a little over $1,000 toward his, toward what he's supposed to get paid. Oh, goodness, I forgot a whole piece of this, and the whole piece of it was that, that he got fired in the meanwhile. Oh, and
You've got 2 minutes.
I'm down to 2 minutes, so I'll skip the firing, but the point is he gets fired, he's still not paid, and he's trying to get paid. And when in October he sends an email and says, where's my money? The answer is this email from Milazzo Webb that from Miss Milazzo that I would read to you if I had more time. I'd ask you to read it yourself. It says, I've talked to other attorneys and they say you did a poor job with the settlements, so we're not going to pay you. And that's just what they did. And there's more to that. There was allegations that multiple attorneys gave her advice that ended up to not be true. It was one single attorney. And that one single attorney testified that no, she didn't give her that advice at all. But even if she had gotten that advice, it is not a good faith or reasonable basis to not pay an employee because they did a poor job. The Wage and Hour Act sets out a whole string of things where you can withhold wages, and among them is not the employee, you think the employee did a poor job. That cannot be a good faith or reasonable basis. About 41 seconds if the court has any other questions.
This car?
No, sir.
Oh, wait a
Thank you,
minute.
sir. Oh,
Well, apparently it's too much for me to take in. Thank you, Your Honors.
thank you, sir. All right. We'll go back to the appellant.
Thank you, Your Honor. First of all, in answer to Judge Airwood's question to me, the order was entered on March 5th, 2021. The order was served on March 30th, 2021. My recollection now that I've looked back at it, something to do with code.
Where's that in the record?
It's in the brief, Your Honor.
It's in the brief, but where is it in the record?
I don't know.
The answer is it isn't in the record. That's at least that I can find. And that's a jurisdictional issue, is it not?
It is, Your Honor. The reason why my client did not pay Mr. Stockton was because I thought he committed malpractice. That's why they pled it as a counterclaim. The policy adherence that counsel...
Did your client ever file a fee dispute?
Yes.
With State Bar?
Yes, Your Honor. In fact, that's further evidence of that. That's exactly what Mr. Stockton thought it was too, because his lawyer sent my client a letter that said, as a precedent to suing you, we got to advise you of the fee dispute resolution. And my client filed a petition. It was clear between the parties that it was a fee
I mean,
dispute.
State Bar declined to take it, did they not?
I'm sorry?
State Bar declined to take it?
There was not a State Bar issue to take one way or the other. It's a fee dispute. I think there's a letter in the record that says that that sets out the purpose of what the State Bar does. I don't know if the State Bar declined it for substantive reasons. I don't think that's what the State Bar does, Your Honor. But what's more important is what the parties thought it was, I think, than what the State Bar might have thought it was. And based on those letters and a petition, both parties apparently believed it was attorney fees, and it clearly was. If you look at the invoice in the record, whether or not it's on Milazzo Webb stationery or not, that's all attorney work. I mean, there's 70 hours worth of entry that show attorney time. And because it's attorney fees, it can't be wages. Attorneys should not be allowed to sue their clients.
Where in the statute does it say that if it's attorney's fees, it can't be wages?
It's not in the statute, Your Honor. But I think as a matter of policy, if lawyers are allowed to
Is
sue,
there any case law that says that either?
not a case that's ever come before the court. I don't think, Your Honor, where an attorney has tried to sue his client for unpaid attorney fees under the Wage and Hour Act. And there's good reason for that. They shouldn't be able to do that. And that would set a precedent now if it was allowed to do that. At this $20,000, $12,000 is attorney fees. Work done defending the law firm, not working for other clients, defending the law firm, just like I am right now.
And that work was done, at that time, was he also under the agreement that he would get a certain percentage of whatever he collected for work he did at the firm?
Yep, but it was
So this work was done in lieu of that?
No, in addition to. So Mr. Stockton was wearing two hats. On the one hand, he was working, he was getting a 75% of what he did, working for Milazzo clients or his own clients. On the other hand, he was supposed to be paid by the hour for work he was doing defending the Milazzo law firm against a wage and hour claim.
But there are only so many hours in the day, so this is in lieu of doing something for someone else.
Well, as I would think most lawyers, if you've got 24 hours, you can bill somewhere close to that if you're capable of doing it. And I suppose he billed a lot of hours, but he was wearing two hats at the same time. The lawyer hat is clearly not under the Wage and Hour Act. And finally, lawyers should not be precluded from entering into independent contractor agreements. And if you uphold the trial court, that's exactly what's going to happen. We'd ask you not to do so.
Judge Everett, any more questions? Mr. Carpenter?
Thank you.
Sir. We will consider this case submitted and take it into consideration, and we appreciate everybody's time today. Thank you very much.
All rise.
John?
This session of the North Carolina Court of Appeals is now adjourned. Yes, sir. Well, I'm a clerk at the Court of Appeals.
But I look forward to seeing you around.